In this learning unit, we look at the criminal trial phase. Now, this phase of proceedings effectively deals with the question of whether the accused should incur criminal liability for the offense or offenses with which he or she has been charged. So in this learning unit, the important part is looking at the different stages or the different steps that must be satisfied before an outcome is achieved. And the outcome that I'm referring to here is the verdict by the court, either finding of guilty or not guilty. This discussion index provides you with the basic framework of the main topics that we will discuss in this learning unit. The criminal trial phase is often that part of the proceedings that is depicted in television shows or in movies. But I want to remind you that that is not the reality in practice. It is not as dramatic as it often seems in the movies. And more importantly, keep in mind the fact that I've already mentioned to you that a lot of the television shows and the movies that we see in South Africa is based on the American criminal justice system, and it's not the same in South Africa. So what we are dealing with here is effectively the criminal trial, also referred to as the trial on merits, and it is about the substantive issues in dispute. The issues in dispute, more or less, is about whether the person committed the offense. And once this person has pleaded not guilty, it means that he opposes the state's allegation that this person is responsible for the commission of a specific offense. And so the criminal trial phase would be that part of proceedings where these two parties, these two sides of the case, the defense and the prosecution, fight out their cases in court in front of an impartial and independent presiding officer in order to convince that presiding officer that their case is the prevalent view or is the truth in this matter. And that is effectively what happens. Both parties bring their relevant evidence, admissible evidence to court in order to prove their case or to disprove something in their opponent's case. But it is really about these two, as we refer to them as fighters in the ring, opposing fighting parties before an independent decision-making individual such as a judge or a magistrate. Before we start with the criminal trial itself, I want to take you a step back and I want to remind you that the accused's plea determines the sequence and the applicability of the next stage in the criminal justice system. And why that is important is because the criminal trial is not always necessary. If a person, an accused, pleads guilty and that plea is recorded by the court, there is no dispute between the accused and the state. And for this reason, there is no need for the prosecution to prove its case, to prove its allegation by the process of leading evidence at the criminal trial itself. So the moment a person pleads guilty, we bypass the criminal trial stage and we move directly to the sentencing stage. And that sentencing stage will be discussed in the next learning unit. And it is therefore not under these circumstances necessary for a court to decide what, if rather, the person has committed the specific offense. It is only necessary for the court to decide what would be the appropriate punishment. However, if the person pleads not guilty, it means there is still a material dispute of fact between the two parties. And before we can assume that this person is guilty, that presumption of innocence needs to be overturned. And only after this process, if the person is found guilty, then we will move on to sentencing. So if the accused pleads not guilty, as we said, this is basically denying or opposing the state's allegation. There is a material dispute of fact. What remains in dispute between these two parties often depends on what the accused was willing to admit to during the plea explanation, if any. If no plea explanation was made, or if no admissions were made during plea explanation, it effectively means that the state will have to prove all of the requirements for criminal liability against the accused. So during the trial on merits or the criminal trial, the state then bears the burden to prove these allegations. Why? Well, because similar to the case in a civil proceedings where the statement or the adage is he who alleges must prove, in the case of a criminal trial, it is the state that is making an allegation, and only if the state has provided a basis for its allegation does the accused person actually have to respond to those allegations. So the starting point is for the state to provide a basis, a prima facie proof of its allegations, and if so, then the accused will have to respond. We refer to that as the evidentiary burden of rebuttal. So only after both these sides of the case have been heard and the accused is then found guilty will we proceed to sentencing. So obviously, the moment a person pleads not guilty, it is generally a much longer process than in the case where a person pleads guilty.
The trial on merits stage is essentially where the two opposing parties go head to head. So both parties will have an opportunity in terms of the principle of aurea alteram partem to present their case to the court and argue, cross-examine. All of these things are part of the trial on merits stage, and for that reason it does take quite a long time. It's the part of a criminal trial or a trial that does take the longest. Now, the purpose of the criminal trial is to come to the conclusion of whether or not the accused is guilty beyond reasonable doubt for the crimes for which he or she has been charged. This means that it deals with the issue of whether or not the state has proven the guilt of the accused beyond a reasonable doubt. Now, two things happen at the end of this stage. Either the accused is found not guilty, and that will be the end of the whole process. He's acquitted and he can go home, or she can go home. However, if the accused is found guilty at the end of the criminal trial phase, we will move on to the second stage of the trial phase, which is sentencing. In totality, the trial phase can be described as a state-sponsored public, judicial and primary oral hearing, in terms of which the alleged criminal liability of an accused must, in the public interest, be determined by an impartial adjudicator on the basis of constitutional, statutory, and common law rules and principles of substantive and procedural fairness, which is aimed at promoting the right of the accused to a fair trial. This result, or consequence of this, is resulting in a reliable and an acceptable verdict of either a conviction, in other words, a finding of guilty beyond reasonable doubt, which is then followed by sentencing and punishment, or a decision by the court that the accused is not guilty and is therefore acquitted because he or she is innocent.
As mentioned, the trial on merits phase commences once the accused has pleaded not guilty in the court with jurisdiction to hear the matter. In other words, the trial court, and that plea is recorded, very importantly. Now, an accused who pleads not guilty is entitled to demand a verdict. In other words, that the issues raised by the plea be fully adjudicated and that he or she either be acquitted or convicted accordingly. So once a person has pleaded, there must be an outcome, and the accused can demand such an outcome. Next important thing is that in South Africa, our criminal trial process follows an accusatorial or adversarial model, as we've discussed. Now, this means that the prosecution and the defense present their respective cases before an independent and impartial presiding officer. Now, to ensure effectively that no person is convicted without a fair trial, The accused is constitutionally entitled to certain fair trial rights in section 35 subsection 3 of the Constitution, and to adjudication before an independent and impartial court in terms of section 34. Now, together with these fundamental constitutional guarantees, there are also important jurisprudential foundations of a fair trial that must be satisfied. Now, in simple terms, these foundations require that judicial authority in criminal proceedings must be exercised independently, impartially, fairly, and transparently. They also require that certain basic processes and procedures, which aligns with the principles of natural justice, must be followed to ensure trial fairness. Now, the principles of natural justice, as we've discussed earlier, refers to the principles of audi altram partem, here both sides of the case, nemo judex in sua causa, no one can be the presiding officer, the judge in their own case. This needs to be done by an independent, impartial presiding officer, and other important principles of natural justice. Now, for this reason, the jurisprudential foundations of a fair trial is very important, and it is grounded not only in the constitutional fair trial rights protected under the Constitution, as we've mentioned, but also some of the common law principles that we have mentioned under the jurisprudential foundations of a fair trial. And we'll unpack these in a little bit more detail on the next slide. During a criminal trial, it is the responsibility of the presiding officer to ensure that the accused is not convicted without a fair trial. So criminal proceedings must therefore be conducted in a way that gives effect to the important principle that justice must not only be done, but must also be seen to be done. For this reason, an accusatorial or serial fair trial is functionally based on a number of constitutional fair trial rights and common law accusatorial fair trial principles as outlined in the slide. Now, looking at these clockwise, the first is the constitutional fair trial principles. These are the constitutionally guaranteed fair trial principles in section 35 subsection 3 of the Constitution, read together with section 34 of the Constitution, namely the access to justice. And they form the cornerstone of an accusatorial trial and ensures that the accused's right to procedural fairness and justice in criminal proceedings is ensured. The second is the open justice principle. Now, the idea here, as we said, is that justice must manifestly be seen to be done, which is why criminal hearings are generally held in open. Criminal trials are usually in open public court, open to the public, and therefore held in the presence of not only the public, but very importantly, in the presence of the accused. Obviously, there are limited exceptional cases in this regard, but the idea is that all accusations and evidence must be presented in open court in the presence of the accused to enable this person to respond to those allegations. Third, the principle of judicial impartiality. Now, this requires that the presiding judicial officer remains unbiased and neutral throughout the trial, and thereby ensuring that both the prosecution and the defense are treated fairly and that justice is administered without fear or prejudice to either one of these two parties. 4, the principle of judicial control. A judicial officer must, without sacrificing his or her impartiality, actively maintain control of the courtroom and regulate proceedings within the bounds of the law of criminal procedure. And that obviously then links to all of the important sources of law relating to criminal procedure. Fifth, The principle of equality of arms between equal parties implies that everyone is equal before the law and has the right to equal opportunity, protection, and benefit of the law during the criminal trial. And this links very directly to the principle of audi alteram partem, where both parties must be provided an equal opportunity to present their case. Number 6, the principle of confrontation in a fair trial. The indication here is that no ruling or judgment should be made without giving both parties that equal opportunity to be heard and to present and challenge their evidence. And this must be done in an open and impartial court, conducted in the presence of the accused and in a language that he or she understands. The effect of this is that the confrontation principle is not a separate stand-alone principle of or foundation of a fair trial, but links with many of the other principles and the constitutional rights, very specifically to ensure that this confrontation during an accusatorial trial is fair and just to both parties. Number 7, the principle of orality. In other words, viva voce. Now in South Africa, there is a preference for witnesses to present their evidence orally. Viva voce. And this is usually done under oath or affirmation, in open court, and in the presence of the accused. And this is achieved through a question and answer process concerning facts within the personal knowledge of the witness that has been called, thereby allowing the opposing party, the party that did not call this specific witness, to hear the version of events of the witness and to also challenge that testimony by the process of cross-examination. Number 8 is the principle of finality. We've already referred to this principle. We said that once the accused has pleaded to a charge, he or she is entitled to demand a verdict, at which point it means that the court is seized on the matter, and it means that a final reasoned judgment must be provided at the conclusion of the trial. So once a party has closed its case, it may only be reopened if there are unforeseen or unexpected new facts or evidence that comes to light, and the accused is entitled to demand an outcome from the moment that he or she has pleaded to the charges. Next, we will look at the accusatorial trial procedures. In other words, the distinct stages or structures or steps of the criminal trial phase. As we've mentioned, the criminal trial or the trial on merits deals with the merits of the matter, the merits that are in dispute, and is therefore based on a confrontation aligned with the accusatorial principles between these two equal, independent parties that fight out their case in front of an independent, impartial judicial officer. And the outcome of this process is either a verdict of guilty or not guilty, and where necessary, the passing of sentence. By way of introduction, I remind you, the only time where there will be the necessity for a criminal trial is if the accused pleads not guilty. Effectively, by doing so, the accused invokes their right to be presumed innocent until proven guilty. That means that there is a dispute between the state and the accused, in other words, the defense, and for this reason, it is going to be necessary for the state to prove the guilt of this person. And for that reason, the state bears the burden of proof to start and then to prove, making use of sufficient relevant evidence to establish a prima facie proof at the close of its case. If the state provides a prima facie proof of its case, it means that the accused will now have to respond to the charges, the substantiated charges of the state, because if the accused does not respond and rebut the state's case or refute the state's case, it means that the state's proof, the state's case, will potentially harden into conclusive proof. So once both parties have been heard, then the question is whether the state's case has hardened into conclusive proof. In other words, the state's case has been proven beyond a reasonable doubt, or whether the accused, the defense, has been able to raise reasonable doubt in the state's case. And so that is part of the process that must be unpacked during the different stages or phases of the criminal trial. As a consequence of the presumption of innocence, the accused cannot be convicted unless the court has considered both sides of the case and is satisfied that the accused is guilty beyond reasonable doubt. There are, however, exceptions where the court will not necessarily have to hear both sides of the case. What is important is that the state or the prosecution must first substantiate its allegations of wrongdoing, of criminal wrongdoing, before the accused is actually required to respond. So that means if the accused fails to establish a prima facie case, prima facie proof, the accused may be acquitted without the defense having to answer to the state's case. That meaning the exception to the aude alteram partem rule. However, if the prosecution does establish a prima facie case, it means that the defense will usually need to respond to the state's case, which has now been substantiated by evidence, in order for the accused to avoid a possible conviction. So at this stage, the defense now bears an evidentiary burden of rebuttal. This means that the defense must place evidence or a defense before the court or rely on weaknesses in the state's case to challenge or to refute the prima facie case against the accused. Now, this importantly does not shift the overall burden of proof, which is on the prosecution. That legal burden to prove the guilt of the accused beyond a reasonable doubt never changes. But what is required if at the end of the state's case there is a prima facie case or prima facie proof of wrongdoing is that if the defense now fails to rebut this proof, the court may well be satisfied that the state has proven its case beyond a reasonable doubt, and the accused may on that basis be convicted. Based on the preceding discussion, we can effectively identify four main components or steps or processes that must be followed during the trial on merits phase. So, the first is that the prosecution, as we said, has the responsibility to start the case and substantiate its allegations against the accused. And then at the end, when it has adduced all of its evidence and the process of examination in chief, cross-examination and re-examination for each witness has been followed, the prosecution will close its case, and at this point there are a number of options available to the defense. Some of which may include, for example, that the plea of the accused can actually be changed from a plea of not guilty to plea of guilty, or that the defense could potentially ask for a discharge, in other words, an acquittal on the merits of the accused. There are other options, but these are things that you only need to take note of. So at the end of the state's case, now, according to the principle of aude alteram partem, it is the opportunity of the defense, if the prosecution has substantiated a prima facie case or has provided prima facie proof of its allegation, the defense, the accused, will have to defend him or herself against the state's allegation, and the same process of adducing evidence will follow. After the defense has closed its case, both parties will have an opportunity to make closing arguments, and obviously each party will indicate to the court or try to finally convince the court of the merits of their arguments, and after this point we will move to the finding of the court. In other words, the verdict. The court needs to decide is the accused guilty or not guilty? Now, if the accused is found guilty beyond reasonable doubt, either based on the charge or based on a competent verdict, the court will then have to, after that verdict, move on to the sentencing stage.
Now, the case for the prosecution, the state's case, is the first step in the criminal trial after the plea of guilty. So after the plea of guilty and the court has gone through the processes of inquiring about plea explanation, formal admissions, and those sorts of things, the state starts its case. Now, why does the state start the case? Well, it's basically because of the presumption of innocence. Because I'm presumed innocent until proven guilty means that there must be a basis for overturning the presumption of innocence. Now, essentially, that means that the prosecution must show a prima facie case which requires the accused to defend him or herself against those allegations. In private law, we talk about the standard of proof being he who alleges must prove on a balance of probabilities. So he who alleges in this situation is the state, is the prosecution. They are alleging that this person committed a certain crime, and for that reason, they must provide a basis for their allegation, which is a prima facie case.
We can break the state's case up into different phases or processes. The first would be the opening address, which is exactly that. The prosecution making an opening statement and providing an overview or a summary of the essential aspects of the state's case against the accused. Then the state will move on to adducing its evidence. Now, it's very important that you understand that in terms of the principle of orality, most evidence is provided viva voce. Now, this means that not only witnesses will be called and will testify, generally speaking, by way of oral testimony, also other types of evidence, even physical objects or documents that is used as evidence, will be accompanied by testimony. What do I mean with this? Well, whenever a party would like to use relevant admissible evidence, let's say, for example, the murder weapon, that murder weapon cannot just be put down on the desk in front of the presiding officer and the prosecution says to the judge or the magistrate, there's the murder weapon. No, someone actually has to come and testify. Where does this come from? Where was it found? What was the chain of custody? What was found in relation to that item? So let's say it's a gun. Was there some kind of ballistic report? Was there DNA, blood, perhaps fingerprints found on the murder weapon, etc., etc. So effectively, whenever evidence is admitted in court, it needs to be done by way of someone testifying regarding the originality and the relevance of that specific piece of evidence. Now, this is something we will come back to later in our discussions when we deal with the relevant principles of the law of evidence. Now, effectively what we are then saying, whenever evidence is being led or testimony, there is a procedure that will be followed for the questioning of a witness. Now, because we are busy with the state's case, at this point, it is the state, it is the prosecution who will start by calling its witnesses. Now, this could be a long list of witnesses, or potentially it might only be one witness, depending on the circumstances. But the idea with calling each of these witnesses is for that person to come and testify, generally in favor of the state, hopefully, and they will be called the one after the other with the intention that together all of the witness statements, all of the admissible evidence adduced in court will collectively serve to establish a prima facie case or prima facie proof against the accused. Now, in the next slide, we will break up the procedure, the individual procedure for each witness. We are now still looking at the state's case, and we want to focus more specifically on the procedure for questioning a state's witness. As we said, the state will now have the opportunity to establish a prima facie case by calling each of its witnesses respectively from the list of witnesses. So for each witness that the state intends to call, a certain process or procedure must be followed. The first important thing is a witness cannot simply walk up and testify. There's a process before any testimony is listened to. And this is the taking of the oath or affirmation, or often in the case of children, these individuals are warned to speak the truth. So only once a witness has taken the oath will they be able to testify. Right. Now the starting point would be examination in chief. The party who calls the witness is responsible for questioning that witness during examination in chief. Now, the questioning in this regard is often very open-ended. In this situation, it is the prosecutor that is calling this witness, and effectively what the prosecution wants to do is they want the witness to tell their version of events, to tell from their personal experience something that is relevant to the crime. Now, this could be an eyewitness, yes, that's a possibility, but it also could be other types of witnesses that we'll talk about later. For example, an expert witness, a forensic and ballistic scientist, or expert in this regard. So there are different witnesses, and witnesses are called by a party for various different reasons, but it has to relate to something relevant to the offense. So what the prosecutor at this stage is doing is allowing the witness, by guiding this witness and asking some questions, allowing the witness to tell the court what this person experienced, what their version of events was, what expertise they perhaps might have that is relevant to this offense, and perhaps what role they've played in the process of gathering evidence or analyzing evidence, or whatever the case may be, whatever the reason is why this witness is called. Remember, the key thing is relevance. Now, in terms of the criminal justice system, we cannot simply assume that that witness is speaking the truth. The credibility of that testimony, the accuracy of the evidence must be challenged. So the moment a party has adduced evidence like witness testimony, it needs to be challenged by way of cross-examination. So here we say that the prosecution has led its own witness during examination in chief and given this witness a lot of opportunity to give their version of events. Now that version needs to be challenged by the opposing party. So if the prosecutor led the evidence of its state witness during examination in chief, now it will be up to the defense counsel to cross-examine, to challenge the version of the state's witness by asking questions. Now here, the idea with cross-examination, as we said, is to test the credibility of the testimony. So difficult questions will be asked of the witness, and the witness will be put to the test to make sure that their version is correct, it is believable, it is credible, and those sorts of things. So here, this part of the process could become a little bit more animated, dramatic, so to speak, because here, depending on the type of litigation technique used by the defense counsel, it will challenge the witness in order, as we said, to make sure that the evidence that they did provide, the testimony that this witness provided, is credible, is accurate, and so forth. Now, after this process, which could potentially lead to some uncertainties, perhaps the cross-examination of this witness has led to the witness being put in a very bad light, their credibility might have been tested, and there's some uncertainty in that regard. It means that after this cross-examination, the witness will be returned back to the prosecution. And if the prosecution wants, because this is their witness, they can re-examine this witness. So it's called re-examination. And the idea with re-examination is just to clarify any potential issues that may have arisen from this cross-examination process, where the idea was really maybe to make the witness look bad, or to make the witness not seem credible, whatever the intention was by the defense counsel. At this stage, the prosecutor can try and I want to say fix those issues or clarify those issues by the process of leading this witness during a re-examination and perhaps providing the witness an opportunity to explain some of the answers given during cross-examination. Remember, during cross-examination, leading questions could potentially be asked of the witness, and that could lead to a situation where a witness answers a question, a leading question, and by answering a question like a leading question, there could be some bad inferences or detrimental inferences drawn from a very short answer, usually yes or no, or something to that effect. Detrimental consequences could be drawn from the statement by a witness during cross-examination, and that potentially may need to be clarified or rectified by the party that has called this witness. It now re-examines its own witness, and only after this point, if there are no further questions, usually that is the case, then that is the end of the procedure for questioning the first or the specific witness. And as we said, the same process will be repeated for each of the witnesses called by the respective party, whether that is the prosecution at this stage or later when the defense starts to adduce its evidence. The same procedure will be followed for each respective witness. After the state has called all of its witnesses and it has adduced all of its evidence, it will close its case. So the idea here is that the state has provided the court its version of events, and it has substantiated its version of events by way of relevant admissible evidence. And once it has done so, it will close its case. Now, it is very important that you understand at this point in the process, the court is not going to consider whether the state has proven its case beyond a reasonable doubt. Because the only way in which the court can decide whether the state has proven its case beyond a reasonable doubt is if it has listened not only to the state's version of events, but also the accused version of events. So only at the end of the trial, when the court has listened to both the prosecution and the defense's versions, can the court decide on whether the person is guilty beyond a reasonable doubt. Now, this means that at the end of the state's case, when the state has closed its case, what is expected, the standard of proof that is expected of the state's case, is a prima facie proof. So not at this stage reasonable doubt, but at this stage the prosecution must have substantiated its allegations by way of prima facie proof. Now, what do we mean with this? This prima facie proof is the standard of proof on the prosecution that effectively means that when the court considers the information, considers the evidence provided by the prosecution, at face value, the court must believe that that evidence is sufficient enough to require the accused to defend him or herself against the state's case. Remember that this prima facie case that the state has provided is not conclusive proof. It may very well be rebutted by the state's version of events. So it's not the end of the matter. That is when we said the aurea altram partem rule is very important. We still need to hear from the defense. But before the defense has to respond to the allegations by the state must have provided a prima facie case. So if the prosecution does not provide a prima facie case, it might not be necessary for the defense to respond to those allegations. But if a prima facie case has been established, then clearly the prosecution has provided corroborating or substantiated proof of its allegations, and the accused or the defense will have to rebut the state's case in order for the person not to be found guilty beyond a reasonable doubt. So Just to remind you, at the end of the state's case, the question is whether the state has provided a prima facie basis, prima facie proof of its allegations. So as we said, if the state is unable to prove a prima facie case, it didn't have sufficient, relevant, and admissible evidence, then the court may, at its discretion, return a verdict of not guilty, acquittal on the merits. Now, this is quite an exceptional situation because usually at the outset, before the state starts to prosecute, they need to have made that decision. We spoke about the discretion to prosecute earlier. And at that stage, the prosecution must have been satisfied that it has a prima facie case, sufficient, relevant, and admissible evidence against the accused, and that is why they decided to prosecute. But it may happen that some of the evidence available to the state might be decided by the court that evidence is no longer admissible, and that could potentially mean that even though at the outset the state thought it had a prima facie case, it has failed to provide a prima facie case for various reasons. And when we say that the court may then return a verdict of not guilty, it means that this person is acquitted, that the accused person is acquitted of this crime without even requiring the person to defend him or herself against the state's allegation. Now, if, however, the state does establish a prima facie case, then it means there's an expectation, there's a need on the accused to respond to the allegation of the state's case. So there's an opportunity to rebut, a very specific word, to rebut the state's case. And now the accused, in terms of, or in line with the principle of audi alteram partem, will have an opportunity to be heard by adducing its evidence. And remember, the moment a party adduces evidence, the other party will have the right and the opportunity to challenge that evidence. After the state has closed its case, having adduced all of its relevant admissible evidence, the accused, now the defense, has the opportunity to put his or her case before the court in line with the principle of audi alteram partem. Now, because the prosecution has successfully established a prima facie case, the accused must respond. But I remind you that this proof, this prima facie proof, may still be rebutted by the defense's case, the accused case. So in order to avoid a conviction, the accused will be required to respond and defend himself against the state's substantiated allegations. Substantiated meaning that the state has provided a prima facie basis for the allegations of wrongdoing it made against the accused at the outset. And this means that the defense now bears an evidentiary burden of rebuttal, and it must present its case in an attempt to raise reasonable doubt. Now think about the wording there. The defense bears an evidentiary burden of rebuttal, and it wants to present its version of the case, its version of events, and by presenting this version, it wants to raise reasonable doubt. Because if the defense is able to raise reasonable doubt, there has to be doubt in the mind of the court. And if that is the case, at the end of these two steps, the state's case and the defense's case, the court will not be able to come to the conclusion, the verdict, that the guilt of this person was proven beyond a reasonable doubt. So if the defense is able to raise reasonable doubt, the decision cannot be that this person is guilty beyond a reasonable doubt, because there is some reasonable doubt. The accused, whether with or without legal assistance, is entitled to remain silent and cannot be compelled to give self-incriminating evidence without any adverse conclusion being drawn if this decision is made. So the idea here is, now that the defense has an opportunity to adduce its case, the first question is whether the accused will testify in his or her own defense. But we are saying that because of the right to remain silent and the right not to be compelled to give self-incriminating evidence, the accused does not have to testify during the trial if they choose not to do so. It could be good or it could potentially be bad for the accused to exercise this choice, but it is important that where this person is legally represented, that this legal representative properly advises his or her client on the best way forward for their case. Obviously, if the person has the right to remain silent, they also have the right not to remain silent. And so for this reason, at this point where it is the case of the accused, of the defense, the accused is entitled to testify and give evidence, but also to be cross-examined and also to call other witnesses in order to adduce its evidence and to put forward its defense. And so for that reason, effectively, the same processes and procedures will play out as we've discussed in terms of the state's case. So the defense will call each of its respective witnesses, and the same procedure, oath, examination in chief, cross-examination, re-examination of each of these witnesses has to follow, usually starting with the accused if he or she decides not to remain silent.
So the main purpose of the defense's rebuttal is to raise reasonable doubt in the state's case. So this standard of proof is referred to as the standard of reasonably possibly true. If their version of events or their defense is reasonably possibly true, then the court cannot find the accused guilty beyond a reasonable doubt. Okay, so those two kind of go hand in hand. If the state has to prove its case beyond reasonable doubt, beyond a reasonable doubt, all the defense needs to show is that their explanation is reasonably possibly true, wherefore the court cannot conclude that the case has been proven beyond a reasonable doubt because the defense has raised reasonable doubt. I hope that makes sense. Now, this standard merely implies that there is a factual basis for the defense's version of events, which means that which raises the reasonable doubt, and therefore the state's case has not been proven beyond a reasonable doubt. If the accused decides to waive his or her right to remain silent and intends to adduce evidence, he or she or their legal representative may address the court for the purposes of indicating to the court without comment what evidence is intended to be adduced on behalf of the accused. Now, if the accused calls witnesses, whether that includes him or herself or other witnesses, the same procedure that we discussed under the state's case will follow. So in this situation, because it is the defense's witness, each of the defense witnesses will be called during examination in chief. Following examination in chief of a defense witness by the defense, cross-examination of that defense witness will follow by the prosecution, and if necessary, re-examination of that defense witness will be done by the defense. Once the defense has closed its case, we've now reached the point of the closing of arguments. So this is the final arguments by both the prosecution and the defense. So now, having heard both sets of arguments by the prosecution and the defense, it is now over to the court to give its final verdict. And in this regard, we will consider the verdict on the merits and the possibility of a competent verdict. The judgment means that the court must consider and deliver its verdict on the merits of the case. Now, in delivering a verdict, the court is required to compare the prima facie case of the state against the defense's attempt to raise reasonable doubt. Only in considering both sides of the case and weighing up all of the evidence and arguments objectively will the court be able to come to a reasonable conclusion or finding, and the expected outcome would be either an acquittal or a conviction. An acquittal or a finding of not guilty implies that the court, again after mature consideration, is not convinced of the guilt of the accused, either because the state has failed to prove its case beyond reasonable doubt. In other words, the likelihood is there was not enough evidence by the state, or the accused was able to raise reasonable doubt in the state's case, or if the accused was successful in raising a defense. In order to find an accused guilty, in other words, a conviction, the court must be satisfied that after mature consideration, there exists no reasonable doubt that the accused committed the crime in question. Thus, in order to obtain a conviction and overturn the presumption of innocence, the court must be satisfied that the prosecution has proven the legal guilt of the accused beyond a reasonable doubt. Now, a finding of guilt can either mean that the accused, or rather that the court is satisfied beyond a reasonable doubt that the accused did in fact commit the crime that he or she was charged with, or if it appears that the accused in actual fact did not commit the crime he or she was charged with, but the court is satisfied beyond a reasonable doubt that the accused did in fact commit another crime with different elements, the court may hand down a competent verdict. And a competent verdict is something that we will discuss a little bit later. So it is the possibility that the accused might be found guilty as charged, or the possibility that the accused might be found guilty on a competent verdict. Now, what do we mean with a competent verdict? Competent verdicts is a concept for the situation where in a criminal trial, the evidence might fall short of proving the guilt of the accused for the crime he or she was originally charged with. But the evidence nevertheless might succeed in proving beyond a reasonable doubt that the accused in actual fact did commit a crime which has elements of a different crime, not specifically formulated as an alternative charge in terms of Section 83 of the CPA to the charge in the indictment or the charge sheet, as the case may be. In other words, this is a situation where the state does not fail in providing prima facie proof. It simply fails in providing prima facie proof on the charges in the charge sheet or the indictment, but successfully has proven its case beyond reasonable doubt regarding a crime with different elements. Now, that means that a competent verdict is essentially a verdict or a conviction on an unexpressed or a latent or an implied charge which only surfaces once the crime charged is not proved, but some other crime with other elements, which usually is a lesser crime or a crime similar in nature to the crime charged, and if that is then proved. So the prosecution is unsuccessful in proving the guilt of the accused on the charges, on the original charges, but is successful to prove the guilt of the accused on a different charge, a competent verdict, beyond a reasonable doubt. Competent verdicts are only possible if permitted by statutory provisions. So for that reason, Section 256 to 270 of the CPA makes provision for competent verdicts to specific types of crimes. So I'm not going to discuss each of these crimes and each of their competent verdicts. This is something that you'll have to do as self-study. I'll probably ask you an application type question and see if you can identify which competent verdicts will be available in a specific set of facts.
That brings us to the end of this learning unit, and it's important that you understand the components of a criminal trial, what things are supposed to happen and the sequence, and also you need to keep in mind how this links and when this links to the next stage of criminal procedure, and that would be sentencing. Obviously, sentencing is only relevant in instances where the accused is found guilty beyond a reasonable doubt, either on the merits or on a competent verdict. So sentencing, the next learning unit, will not be applicable if the person is found not guilty.